Thank you, Mr. President. It's my privilege to bring to you today Senate Bill 129, the Georgia Religious Freedom Restoration Act. I'm going to take a few moments to kind of set the predicate why this bill is needed. Then I'm going to go through the bill itself. Then I'm going to try and anticipate what I believe we will hear in some of the floor debate and respond to that in an anticipatory way. The notion of religious freedom and protecting religious liberty goes back in the Western legal tradition over 800 years. You can go back and look at the Magna Carta in 1215 when the English church received guarantees to be free, to have its rights undiminished, and its liberties unimpaired. And that resulted from a sovereign, from a government that was murdering church officials. And so there was great consternation in the land about people not being free to worship as they so chose and to have the freedom of their conscience. And so the king, who up until that moment had absolute power, signed a document for the very first time limiting the rights of the sovereign, and the very first thing enunciated in that document was religious liberties. So you fast forward to the late 1700s, the United States Constitution. In the Bill of Rights, the First Amendment clearly provides that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, from that time forward, courts interpreted the First Amendment and objections made to government action that infringed on religious liberty in a number of ways. But in the modern era, the compelling interest standard was first articulated in a case called Sherbert versus Verner. And in that case, the United States Supreme Court clearly outlined 4 criteria that are used to determine if an individual's right to religious free exercise has been violated. And the test is as follows. For the individual, the court has to determine first whether the person making a claim has a sincere religious belief. Then they must determine whether the government action is a substantial burden on the person's ability to act on that belief. Now then and only then, if those 2 elements are established, then the government has to prove that it's acting in furtherance of a compelling state interest and that it has pursued that interest in the manner least restrictive or least burdensome to religion. So the Supreme Court established that in 1963, and for 27 years in federal courts and in every state court in this country, that is the standard that was used for First Amendment free exercise cases until 1990. In 1990, the Supreme Court decided a case called Employment Division versus Smith. And in that case, they abrogated the compelling interest test. They said, we're not going to follow the compelling interest standard anymore. And there was a national outcry about that because lowering that standard meant that it became much easier for government to trample on the right of free exercise of each and every American. And so Congress passed in 1993 the Religious Freedom Restoration Act. It passed, it was so uncontroversial at the time that it passed on a voice vote in the United States House of Representatives unanimously. It passed 97-3 in the United States Senate. It was signed into law by President Bill Clinton. So then 4 years later, so from 1963 to 1990, Georgia lived under the standard of the compelling interest test. Then again, from 1993 to 1997, Georgians lived under the compelling interest standard for these free exercise claims. It was only in 1997, in the city of Byrne versus Flores, that the United States Supreme Court held that Congress's action in adopting the Religious Freedom Restoration Act could only apply to federal government action. And so it was then, from 1997 forward, that we began to see states act on their own to adopt their own Religious Freedom Restoration Act. And today, 18 years since that decision, 30 states, either through legislative act or through a court decision, have adopted this compelling interest standard. So that's the background. Let's talk about the actual text of the bill, which will be a refreshing change in the debate on this subject. Section 1 is the name of the bill, the Georgia Religious Freedom Restoration Act. Section 2 begins at line 14 with a series of legislative findings. The first of these findings is that the framers of the United States Constitution and the people of this state recognize that free exercise of religion is an inalienable right that is secured by both the First Amendment to the U.S. Constitution and in paragraphs 3 and 4 of Section 1, Article 1 of Georgia's Constitution. Next, we find that laws neutral toward religion may burden religious exercise as surely as laws intended to interfere with religious exercise. Then we find that governments should not substantially burden religious exercise without a compelling justification. They ought to have a good reason to burden your religious liberty interests. If you move on to page 2, we get to the fourth finding, which is that in Employment Division versus Smith, the case I mentioned earlier, the Supreme Court virtually eliminated the requirement that the government justify a burden on religious exercise imposed by laws neutral toward religion. We go on to find that the compelling interest test that has been set forth in prior federal court rulings is a workable test. It worked for 27 years before Employment Division versus Smith, and it has worked for 22 years since the adoption of the Federal Religious Freedom Restoration Act. So we find that that compelling interest test is a workable test for striking sensible balances between religious liberty and competing prior governmental interests. In the city of Byrne versus Flores, the Supreme Court held that the compelling interest test provided for in the federal act has to be adopted. It must be adopted by a state through legislative act or court decision. We cannot simply pick up the federal act because the Supreme Court has prohibited it. And the next finding I want to mention to you is something that you won't find in the Federal Religious Freedom Restoration Act. It is something that we put into this bill to make it as perfectly clear as we can about what the intentions of the authors and sponsors of this legislation are. And that is finding 7. Courts have consistently held that government has a fundamental overriding interest in eradicating discrimination. Those are the findings. So then we move on to the purpose. The purpose of this law is to restore the compelling interest test as set forth in Sherbert versus Verner and Wisconsin versus Yoder, and to guarantee its application in all cases where free exercise of religion is substantially burdened, and to provide a claim or defense to persons whose religious exercise is substantially burdened by government. So that's the findings and that's the purpose. So we then move in at lines 42 with 50-15A-2. This is where we put into code the compelling interest test that I articulated earlier. Government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, except as provided in subsection B. Government may substantially burden a person's exercise of religion only if it demonstrates that the application of the burden to the person is in furtherance of a compelling governmental interest and the least restrictive means of achieving that compelling governmental interest. And a person whose religious exercise has been burdened in violation of this chapter may assert that violation as a claim or defense in a judicial proceeding and obtain appropriate relief against government. Now, In any action or proceeding to enforce a provision of this chapter, the court or tribunal may allow the prevailing party a reasonable attorney's fee. That comes straight from the Federal Religious Freedom Restoration Act. So if you move on to page 3, this is not in the original act, but it is in a subsequent federal law. At lines 57 to 64, we have language that specifically deals with the application of this test in a penal institution, in a prison environment. That's at lines 58 to 62, and that's to make sure that they're able to maintain good order and discipline in those facilities. At lines 63 and 64, we put this in at the specific request of the business community. We make it clear that nothing in this bill shall be construed to create any rights by an employee against an employer if their employer is not government. Then finally, at lines 66 down to 90, we have the definitions. We define what a delinquent act is. That goes back to the penal institutional language. We define what demonstrates is, meaning that you meet the burden of going forward with evidence. We define exercise of religion, which simply means an exercise of religion, whether or not compelled by or central to a system of religious belief under paragraphs 3 and 4 of Section 1, Article 1 of the Georgia Constitution, or the Free Exercise Clause of the First Amendment to the United States Constitution. We define government, and it's a definition that I think anyone in this body would be familiar with. We define penal institution, and we define restrictive custody. Then on page 4, we have the normal effective date and repealer language. So that's everything that's in the bill. Now, I do want to talk a little bit about some of the criticisms that have been heard. Now, you have this item here on your desks that the senator from the 36th has placed there, and it sets forth several arguments, and I think it's important to respond to those arguments. The first thing it says is that this bill would put an individual's religious beliefs ahead of the common good. Not true. What this bill does is it establishes a test for courts to weigh the individual's religious liberty interest against the common good, and it's up for the court to make that decision. So that's just simply not true. The second item that's mentioned is that it could unleash a wave of costly lawsuits that will add burdens to both the courts and taxpayers alike. And I would turn your attention to a July 2010 South Dakota Law Review article which reviewed state religious freedom restoration acts around the country. And what they found after a 10-year study was that there were 4 RFRA claims litigated to decision in Idaho, 3 in Oklahoma, 2 in South Carolina, 1 in Alabama, 1 in New Mexico. More than 16 million people at that time covered by religious freedom restoration acts, over more than 10 years in 5 states, have apparently litigated just 11 state religious freedom restoration act claims to judgment. So there has been no explosion of litigation. That's not true. The facts don't bear that out. And the reason the facts don't bear that out is when you adopt a Religious Freedom Restoration Act, when you adopt a compelling state interest test that has decades and decades of case law at the federal level behind it, you have a bright line so that that attorney who is advising a state agency or a school board or a county commission or a municipality, they can tell them clearly if the policy that they are suggesting going forward with runs afoul of Religious Freedom Restoration Act language. So not only does it not cause an explosion of litigation, it reduces it. Third, it is unnecessary, I'm reading from the senator from the 36th handout. It's unnecessary because our freedom of religion is already guaranteed and protected by the U.S. Constitution and Georgia State Constitution. Here's what I would say to those that say, well, the constitutional language is sufficient. To those who are particularly passionate about Second Amendment rights and who have been in this body for more than a year or two, you know that almost every year we have legislation dealing with gun rights and with rights related to the Second Amendment. We've had a hearing this week on no-knock warrant legislation. I didn't hear anybody at that hearing say the Fourth Amendment is sufficient. We can just use the Fourth Amendment. We don't need any state legislation. How about the Fifth Amendment and civil forfeiture? We've had bills on civil forfeiture for the last 3 years. The Seventh Amendment. My friend, the senator from the 21st, has had legislation having to do with medical malpractice reform and the Seventh Amendment's right to a trial by jury. So all of these things are constantly litigated within the legislative process. And the notion that simply the text of the First Amendment is enough is incorrect. It's incorrect on its face, because courts need direction on how to interpret the First Amendment. Courts need direction on how they are going to referee these claims as they come down. And right now in the state of Georgia, an inmate in a federal prison has greater protection of his religious liberty than an ordinary tax-paying citizen of this state. Fourth, the state RFRA could legalize discrimination. Wow, we've heard a lot about that. Now, I mentioned to you, from 1963 to 1990, this was the law of the land at the federal level and here in Georgia. From 1993 to 1997, it was the law of the land at the federal level and here in Georgia. And for the last 22 years, it has been the law at the federal level. But in fact, it's also been the law in 30 other states, including every state that borders Georgia. Now, I introduced this legislation for the first time in February of 2014. And I have asked this question over and over again. I have asked for the opponents who make this scandalous charge to present one case, one reported case, where a Religious Freedom Restoration Act has served as a license to discriminate. And how many reported cases have been presented to us? How many were presented in the hearing that we had before the Senate Judiciary Committee this year or last year? Zero. Not one. Not a small percentage, not a minimal amount, not one time. Now, my friend, the senator from the 49th, and I have discussed this analogy, and I promised that I would not bring Honda Motor Company into this, so I'll use myself as an example. I recently purchased a Chevrolet Tahoe. And if you had come to me and told me that my Chevrolet Tahoe had a fatal flaw and that the engine block would explode after I cranked it up a few times, how many times would I have to start that car before you began to disbelieve that accusation? If I started the car 100 times and the engine block didn't blow up, how about 1,000 times? What if I drove the car for 22 years without any problem? I hope I'm able to do that. You would say that that criticism is totally unjustified. And yet that is exactly the situation we have with this law. This law is tested. This law has been litigated. And the parade of horribles that we've had to hear about for a year have never manifested themselves. Now, there's been some discussion about what problem are we trying to solve. A lot of people have suggested that there is no problem that needs solving here in Georgia. And I just want to go over a few of the examples. In the Atlanta public school system, in Sutton Middle School, the district allowed many student clubs to meet before, during, and after school without charge and to have access to facilities of the school. And there was a student who wanted to be able to use the school facilities for a religious student club, and he was repeatedly denied. Now, you're going to notice in the minority report that they say, well, this doesn't matter because the issue was litigated and he eventually was able to get some relief. So let me get this straight. The minority is satisfied with the legal environment where all we're saying is, if you're a sixth grader and a school administrator tells you you can't do something, somebody who's in authority, as long as you know to complain about it and go hire legal counsel, your problem will be solved. You have the absolute right to free exercise as long as you've got a lawyer nearby. The same thing is true in the example of Savannah State University, where there was a Christian student organization that held a foot washing ceremony on campus. And a university administrator said that violated the hazing policies of Savannah State University. And so they kicked the group off campus. Now, yes, a couple of years later, after very lengthy litigation, they were able to get back on the campus. But the question is, what kind of legal environment do we want to have? Do we want to have the legal environment where the tie goes to the government bureaucrat making a heavy-handed decision that tramples on someone's religious liberty? Or do we want a legal environment that says every voice is respected, every person of faith is going to be respected, regardless of what that faith is? That's what Senate Bill 129 is about. And we've seen these examples all over the country, not just here in Georgia. We've seen municipalities ban feeding the homeless. We've seen academic institutions require students to stomp on an image of Jesus as part of a academic requirement or face discipline for failing to follow through with that assignment. These things are happening, and they're happening every day, and they're happening here in Georgia. Now, there are quite a few people that talk about this could hurt our economy. It could hurt our economy. 30 other states have this law in place. The state of Texas has this law in place. I don't think they're hurting for jobs out in Texas. The notion that this is going to somehow damage our economic development prospects is totally without merit. There is no evidence to support it. And in fact, I'll tell you, I had a conversation with someone who was making that argument. And this individual was getting ready to move up to the great state of Illinois, which, by the way, Illinois has this law in place. Back when our president was a state senator in Illinois, he was a co-sponsor of that legislation. But he's going up to Illinois, this individual, to advise the new governor up there. And he was telling me about how bad this would be for Georgia, the albatross we would be putting around Georgia's neck in terms of economic development if we dared to put the compelling interest test back into state law. And I said, well, are you going to tell the new governor of Illinois that, I mean, one of the first priorities when you get up there, you've got to get that off of Illinois' back, right, so that y'all can get your economy moving and going again. And his response to me, I think, was very telling about the opposition to this legislation. His opposition, his statement back to me was, well, we're talking about Georgia. And I think that there is a, right beneath the surface for a lot of the folks that are opposed to this, a real contempt for the people of this state. And frankly, for the judicial branch in this state. What is different about Georgia judges where they can't apply the compelling interest standard in a fair and equitable way as judges in 30 other states have, and as has the entire federal judiciary has? It simply doesn't wash. So if that's true, if all of that is true, why is there such loud opposition? And I will tell you, the reason people are very upset that this bill is moving is they're trying to figure out what they're going to put on an email to raise some money once this bill passes. Because the truth is, when this bill becomes law, we're going to see the same thing happen here that's happened in the 30 other jurisdictions. It's going to be very quiet. We're going to see, over the course of several years, policies change that are more friendly to people of faith, that undergird religious tolerance for each and every one of us. But we're not going to see any of this parade of horribles. And the sooner this bill becomes law, and the sooner that becomes apparent, and what credibility remains of the professional left that has opposed this is diminished, that it creates a real significant problem for them. And I will close and certainly be available for questions. Let me say this. For the last 2 years, passing this little 3-page bill that I've gone over with you, that I've read every word to you, that as closely as possible mirrors federal law that's been in place really for a total of 49 years if you add the pre-Sherbert years. It's a simple, modest, common sense protection for people of faith, people of every faith. And when we have strong religious liberty, what goes along with that is tolerance for people of every faith and people with no faith at all. And the fact is that this law has been able to stand side by side with lots of other advancements and rights for groups, every kind of group you can imagine. And it has not caused a problem anywhere in the country. So with that, Mr. President, I'll be glad to yield to any questions if there are any.
There are a couple of questions, Senator. Chair recognizes Senator from the 44th for a question. 44th for a question.
Thank you very much, Mr. President. Does the senator yield?
Yes.
Senator, I know you said in your comments that there's no discrimination. I just see this as discriminatory. You know, people say all day long, I don't discriminate against you because of the color of your skin, or I don't discriminate against you because of the gender, and that's basically what they're doing. But I just want to make sure that I understand you, or let me just ask you point blank again. Do you feel that many persons will discriminate against various groups and then run around all day long pretending that this is religious freedom? Just yes or no? No,
Senator, I don't believe that at all. And what I believe is that this law is narrowly tailored to deal with when the government tries to take an action that infringes on an individual's religious liberty. It is an action between that person of faith and a local unit of government or the state government. It's just that simple.
Okay. Will you further yield?
Yes.
Now, does this law apply to people of all faith? I guess I need to ask that.
Yes, it applies to people of each and every faith.
Okay, very good. Thank you.
Recognizes Senator from the 39th. 39th.
Will Senator yield?
Yes.
Good. Thank you. I just wanted to clarify a couple of things. One, in the instance where you talked about the image of Christ being stomped on as a class requirement, isn't it true that in that instance, one of the students in that class, after the class, threatened the professor with assault, and that was what the student was arrested for, not, you know, or punished for rather, but he threatened the professor. And by the way, it's my understanding the professor was a Sunday school teacher, a devout Christian, and was using it as an exercise about the sanctity of images and, you know, the icon analysis. But beyond that, isn't it true that the student had threatened the professor after the class?
My understanding is that after the university entered into a confidential settlement with the student after he retained counsel, that they made an after-the-fact statement to that effect.
Okay. And if the senator will further yield, talking about counsel, and remember, I'm not a lawyer, I'm a lay person. I don't know a BVD brief from a legal brief. But let me ask you this question. Isn't it true that RFRA, you talked about how in several instances people would have to go to court in order to get redress, had to go to court in order to get redress. Isn't it true that with the bill that you're presenting to us, if it was to pass into law, go to the governor's desk and become law, wouldn't it affect anybody who wanted to take advantage of that have to go through the arduous legal process in order to get relief as well?
Well, and obviously it provides a mechanism to go to court, and I don't dispute with your characterization of that. What I said earlier and what Tim Schultz said in his testimony to the committee is that having a bright line legal standard and a legal standard that shifts the ground in favor of the person of faith makes it less likely that we're going to have policies that are hostile, that get people into a court environment in the first place. And that's a big benefit, I think, of Senate Bill 129.
Will the Senator further yield?
Certainly.
So you're saying that lawsuits are less likely under this bill than they would otherwise be?
Yes, and that's again, quoting from the Law Review article earlier that I mentioned, in states that have adopted their own Religious Freedom Restoration Acts, the folks that have studied this have seen that there have been a very minimal number of suits, and I would attribute that to, this is certainly my opinion, but I would attribute that to the fact that there is now a bright line legal standard that lawyers can advise their clients on.
I appreciate that. We'll just have to agree to disagree on that. Thank you, sir.
I'll
The
yield the
senator's
well.
time in the well has expired. Senator from the 42nd